U.S. District Judge Aileen Cannon has set a date, June 24, for a hearing that will address the prosecutor's plea to modify the terms of release for former President Donald Trump. This intriguing case, unfolding in the Southern District of Florida, revolves around a staggering 40 charges linked to the alleged mishandling of classified documents. Special Counsel Jack Smith has fervently requested a gag order against Trump, asserting that the ex-president's remarks regarding the law enforcement officers involved in the case pose an imminent and grave threat. The prosecution yearns for the judge to unequivocally state that Trump is forbidden from uttering statements that endanger the law enforcement agents participating in the investigation and prosecution of this intricate affair. Trump, who defiantly pleaded not guilty during his arraignment last year, was initially granted release under standard conditions. These conditions encompassed attending various court proceedings and strictly abiding by all federal, state, and local laws. Furthermore, Trump was explicitly instructed not to contact any fact witnesses disclosed by the government. Should he be found guilty of breaching his release conditions, Trump could face dire consequences, including arrest, detention, the forfeiture of bail, and a contempt sanction that could lead to imprisonment or hefty fines. A substantial portion of the legal proceedings in this classified documents case has been concealed, owing to the delicate and confidential nature of the information at hand. However, Judge Cannon recently issued a decree to unveil certain documents that either lack sensitive information or can be released after specific edits have been made. Among these documents was a law enforcement strategy devised prior to the FBI's raid on Mar-a-Lago, a particular line granting permission for the employment of lethal force solely when absolutely necessary, began circulating on various news outlets and social media platforms. In response to this revelation, Trump took to his Truth Social platform on May 21, asserting that the Justice Department had authorized the FBI to use deadly, lethal force. Expanding on this claim, he further propagated the message through an email blast proclaiming, "They were given the go-ahead to shoot me." An FBI representative clarified that the language employed in the Mar-a-Lago raid plan adhered to standard procedure. The FBI adhered to standard protocol during the search, as we do for all search warrants, which includes a customary policy statement limiting the use of lethal force, the representative stated. No additional measures were ordered, and there was no deviation from the usual course of action in this instance. Following Trump's Truth Social post, the prosecution filed a motion requesting modified release conditions, effectively imposing a gag order. In a captivating display of rhetoric, they contended that Trump's speech lays bare the vulnerable agents, leaving them exposed to the perils of threats, violence, and harassment. They further accused him of deliberately deceiving the public with his messages regarding the agents involved in the raid, persisting in his misleading rhetoric, even after the FBI clarified the matter. As the trial approaches, the prosecutors intend to summon FBI agents as witnesses, aiming to establish that Trump, in a reckless manner, has painted a target on the backs of these agents. They pointed to a planned attack on an FBI office in Ohio by a Trump supporter in 2022 as a chilling example of the potential danger posed by Trump, urging the court to take swift action. The prosecutors argued that immediate measures should be implemented to curb this perilous campaign, aimed at tarnishing law enforcement. This plea marks the fourth request for a gag order against Trump, all of which have been grounded, in part, on the belief that the presumptive Republican nominee's influence could incite his supporters to harass anyone he publicly criticizes. While the Supreme Court typically upholds the principle that individuals cannot be held accountable for the actions of third parties in response to their speech, unless it explicitly calls for imminent, unlawful conduct, judges in various jurisdictions have deemed it necessary to impose gag orders on Trump to ensure a fair judicial process. Trump's legal team has contended that the prosecutors have failed to demonstrate how his words hinder a fair trial, but the judges have disagreed. The decision to prohibit speech in advance is at the judge's discretion, but it usually requires substantial evidence. Trump's defense argued that the prosecution has not met this requirement, and that imposing a gag order would be an excessive, sweeping, and unconstitutional act. In the defense's response brief on June 14, it is stated that even after almost 3 weeks since the office mentioned a Truth Social post, they have not presented any proof to the court regarding threats or harassment resulting from President Trump's protected speech. Not a single FBI agent involved in the raid has provided an affidavit, or even argued that President Trump's remarks endangered them. With no evidence to support the claim that Trump's recent statements about law enforcement have caused harassment, threats, or intimidation, The defense maintains that the risk mentioned by the prosecutors is merely hypothetical and insufficient to justify a gag order. They assert that Trump has the right to criticize the government and its agencies' methods, and that the prosecution's reaction has been disproportionate. The defense contended that the proposed restriction is so expansive that it would grant prosecutors the power to apprehend and temporarily confine President Trump whenever he expressed an opinion they disagreed with. This would encompass not only his statements during debates, on the campaign trail, and on social media, but potentially even communications made by his campaign staff. Judge Cannon is scheduled to consider these arguments during an